Jumping to the first topic, local requirements and requirements set by Cabinet of Ministers rules. So to look for zoning requirements of the planned projects, there are two sources. The first and the main one is zoning requirements set by a local municipality. And there you can find requirements which are applicable to a specific area. And then there are general requirements which are regulated by Cabinet of Ministers rules. And those apply to whole territory of Latvia. So also, of course, to the territory where the project is located. Local zoning requirements usually set at least some conditions which are specific for placement of wind turbines. And those usually are a type of land where the wind turbines can be constructed. And those usually are agricultural and industrial land, and also in some cases, forest land. And also there are limitations regarding the distances from residential houses and areas, from some nature protection zones, and also distances among wind turbines. If we are talking about general requirements, those actually are quite similar, meaning they regulate quite similar aspects of zoning issues. And again, places where places and type of land where wind turbines can be located, and those are agricultural, industrial, technical, and also forest land. Then regarding the distances, if the wind turbine is with power up to 2 megawatts, then it cannot be placed closer than 500 meters to residential houses. And if the power is above 2 megawatts, then this distance is at least 800 meters. And regarding distances from nature protection zones, those are not fixed in general rules, but it is provided that these distances basically are set during the environmental impact assessment procedure. And according to the at least current legal regulations, environmental impact assessment procedure is mandatory for precondition if you plan to develop a wind park. So as you see, because both these documents regulate quite similar aspects of zoning issues, they may contradict. And in practice, we usually see that the issue is with type of land where wind turbines can be built, because according to the general rules, forest land is a type of land where it can be done. However, according to local rules, sometimes they are basically silent whether forest land is or is not the place where the municipality is allowed to construct wind turbines. And the second most usual contradiction is regarding distances, because according to local rules, sometimes the distance from residential houses is 1 kilometer, or even we have seen 2 kilometers for wind parks. And again, according to general rules, these distances are usually smaller. So what can be done if there are such contradictions? Unfortunately, local zoning requirements and general rules does not provide a straightforward answer, because from one side there is autonomy principle of municipalities, which allows them to set zoning requirements at a local level. And however, from the other side, there is this higher level legal document, which is Cabinet of Ministers rules. And according to general principles of law, it should be applicable directly. So after analyzing both these documents, as well as looking at other related laws and principles, We are of opinion that yes, these cabinet of ministers rules are prevailing, and therefore they can be applied directly in case of contradictions. And actually, we also see that in recent years, municipalities also tend to support this approach, and therefore providing more flexibility to developers. However, I have to note that unfortunately this has not yet been tested in court, so we don't really know how the court would deal with this situation. Going to the next topic, so detail plan. For starting, what it is. Detail plan is a zoning document which is prepared by a developer and approved by municipality for a specific territory, usually it's project-related territory, to detail zoning requirements which are set by the local municipality. And considering that it is quite a complex procedure, usually involving working with several authorities and organizing public hearing, then it usually takes approximately 8 to 12 months to prepare and finally approve the detail plan. However, from time perspective, it's actually not that bad because it can be done in parallel with environmental impact assessment procedure, and also to a certain level can be combined with the design process. Although I have to say that in practice, we haven't seen, especially with respect to wind projects, that these procedures are combined with the design process. However, it's good that law allows to do so. So in which cases detail plan is required? Most commonly, it is when local zoning requirements sets development of a detail plan as a mandatory precondition for some specific development. And regarding wind turbines and parks, it is usually that if a construction of a wind turbine is at least with power of 20 kilowatts, then a detail plan is requested. And other option is that there are specific territories set in local requirements, which basically requires any big scale for any big scale development to organize and approve the detail plan. For example, usually those are either agricultural land or, for example, forest land. And another ground for detail plan is when specific traffic solutions are required and if those solutions affect state or municipality roads. For example, if a connection to such road is being constructed and due to rearrangement of borders, some land unit is left without an access. However, we see this more as a theoretical in case of wind projects. However, of course, in some cases it may apply also to wind turbine projects. So what a developer can do in case and to understand what zoning requirements it should apply and whether a detail plan is or is not necessary. We see as an option to get to request from a local municipality a binding statement. In Latvia, it's called uzziņa, and where municipality provides legally binding statements in a form of answers to particular questions on how it will act in future under certain legal or factual circumstances. And in practice, we actually have done it. We have asked specifically to municipalities to answer whether whether which zoning requirements are applicable to specific project, and whether a detailed plan is required also for specific project. Another good aspect of this document is that it is binding to the municipality, but it is not binding to the developer. So municipality must actually follow the statements which are provided in this document. However, there is no such obligation for the developer. However, this document is limited to certain legal and factual circumstances. And if these circumstances change, the municipality's actions may also change. And it may happen in case if after obtaining this binding document, for example, laws change, or if some factual circumstances of the project change. And in such situations, we usually suggest clients to, when apply for this document, to include in the application as much as possible technical information about the project. Location of the project, location of each wind turbine, height of each wind turbine, total power of the project, as well as power of each wind turbine, and maybe some other technical information which is available at that stage. And it is necessary because if this information is provided at some later stage, it can be a ground for municipalities to say that this is actually a change of factual circumstances because they did not know this information when they issued the initial document, and this may give them ground to actually change and do not follow the previously issued document. Another issue of this binding statement is that it gives some legal certainty to the developer with respect to municipalities' future actions. However, it does not really mitigate risks related to third parties' rights to challenge such future actions. For example, if a municipality following their binding statement at a later stage issues a construction permit. However, it has issued it without development detail plan or by applying faulty zoning requirements. The parties still can challenge this this construction permit, and of course it may either stop or at least suspend for some time period development of the project. So what other solutions are available? We see that due to administrative and territorial reform which happened in Latvia during recent years, a lot of municipalities are in process or are planning to amend existing or to develop a new local zoning requirements. So if a developer sees that such processes are happening in the area where the project is planned, it should, at least we advise, to actively participate. And there are several options how to do it. For example, by participating in public hearing and by submitting applications with the proposed zoning requirements. For example, if the current local zoning requirements are more stricter than general rules, then a developer can propose to municipality to align these zoning requirements so they basically are the same as they are in general requirements, or to ask not to have a detailed plan as a mandatory precondition for development of wind energy projects. And as the last solution is that developer always may request a municipality to actually amend some part of the local zoning requirements, for example, regarding the specific area of the project. And there is a separate procedure provided for that, and it's a development of a local plan. But issue here is that the municipality is under no obligation to agree to that. Again, in recent years, we see that actually municipalities are trying to cooperate, and they are willing to do so, to use this procedure. But yes, it is not, of course, guaranteed. And from time perspective, I would say that development and approval of a local plan again would be at least 1 year or maybe even a bit more. Thank you, and this was all what I plan to share with you today. Thank you for listening, and Victoria, back to you.